Well,
Yes, Mr. Singh.
madam, that status matter item 50 is in custody, my lord. So my prayer it may be taken
Okay. We'll take up.
as a first.
We'll take up.
Right.
Yes, yes.
Wait, please, Lordship. Lordship, I'm praying for listing of a read petition in the next week, Lordship.
What's the matter about?
Lordship, matter is about read petition criminal, Lordship. The petitioner's fiancé was disappearing. So, police was not taken any action regarding his complaint, Lordship.
Why is it before DB?
Lordship, petitioner and victim girl was supposed to
No,
get.
why is it before a DB?
Lordship, it is habeas corpus petition, Lordship.
Habeas corpus?
Yes, Lordship. And as for roster, this bench is taking.
No, that is okay. Habeas corpus, you are seeking what? Who is missing?
Petitioner's fiancé was missing, Lordship.
You have lost an affair.
Yes, Lordship. The respondent police authority was not taking any action regarding his e-filing petition.
Fresh matter.
Yes, Lordship.
When did you file?
Lordship, it was filed on 1901, Lordship.
Not listed as yet.
Yes, it was listed, but it was not taken, Lordship.
It was left out.
Yes, Lordship.
Monday.
Deeply obliged.
Monday.
Deeply obliged, Lordship.
My lord, item number 21, my lord.
Yes.
Item 21, my lord. 21 matter may be taken in the next week, my lord. Because I am replaced, my lord, today.
Wait for your turn, because these are the matters where probably the LCR was called for.
Today I am not having the brief, my lord. Today, my lord, the brief is not with me, my lord.
Doesn't matter.
Yes, my lord. Okay.
May it please, Lordship, I beg to mention item number 34 and 35. Lordship, conductor council is met with a road accident, Lordship.
Okay.
Adjourned for 3 weeks, Lordship.
You are keeping a note. Let the matter reach. Yes, next.
May please,
Yes.
Lordship, sir, item number 18, my lord. Kindly adjourn for the day, my lord. On behalf of SC as well. You have some.
Wait for your turn. These are the matters we'll take up because whether the LCR has been called for or not, we do not know. Let us see. Wait for your turn.
Lordship, I beg to mention WPC number 3921/23 for listing
For what?
for orders. Lordship, may kindly list the matter on 13th.
What is the urgency?
of-
Why you have mentioned? What is the reason?
Sir, Lordship, it's for non-payment of contracts bill,
Non-payment of?
non-pay contractors bill.
Why before disco? Is it a writ appeal?
No, WSP deputy.
Repeat, why repeat? You are agree, WPC or WA?
WBC.
WPC, why before this bench?
Mm,
Contractors bill. WPC, we take up only some specified repetition.
This bench relates to only specific bench, foreigners tribunal, another
Okay.
habeas corpus matter. Why you
Excuse me,
mention-
sorry, Lordship.
These are bench four matter, madam. Check up. Consult some of your senior,
Yes, sir.
they will guide you.
Lordship, kindly the matter will pass over only for the timing, Lordship.
Hold on, hold.
Which item?
Item 9, Lordship. I don't have the brief with me.
Order 9 will have much. What grounds did you have in your order 9 rule 13?
Lordship,
You filed order 9 rule 13.
Lordship, I don't have the brief.
You don't have the brief, you know little bit about the fact.
Lordship, the ex parte order was passed in the year 2016, Lordship. After receipt of the notice, Lordship, the petitioner took time to file written statement, Lordship. Thereafter, he went to Sibsagar, Lordship, as he was a daily laborer. Thereafter, the ex parte order was passed, Lordship. In the meantime, Lordship, when the proceeding was pending, Lordship, he went to Kerala, Lordship. Thereafter, the petitioner's brother-in-law, he filed a review petition, Lordship, in the year 2019. That was also a Lordship dismissed.
Review tribunal has got the power of review. I don't think so.
Lordship in a month.
Then
In a month,
what about
Lordship.
your order 9 rule 13 petition? Did you file order 913?
No, Lordship.
You filed review.
Review, Lordship.
What happened to the review?
Lordship, that was dismissed, Lordship. Last page. Lordship, I have annexed the miscase, Lordship. Lordship, page 50, Lordship, Annex 7, that is the miscase, Lordship. It was filed under section 3. And the order is at page, Lordship, 58, against the review petition. Notice. Yes, Lordship. Lordship had asked us for the notifications of IMDT. We put it in the mail also, and I have one copy with me, Lordship. IMDT notification. The directions are there in Sarvananda Sonowal, but the notifications are just for the new tribunals, Lordship. Lordship had sought for the notifications, but the
By
direct,
which the matters now been referred to the foreigners tribunal.
yes. But the directions are there in Sarvananda Sonowal 1, Lordship.
And on the basis of these directions, only these three notifications could be found, Lordship. Page 671 of Sarvananda Sonowal, Lordship. And directions of the IMDT Act, Lordship. D, E, F, and G.
Hard. During the period when the IMDT full completed, Act was in force. Mr. Bora, take it.
Yes, sir.
In a proceeding against the petitioner, Learned Furnace Tribunal, Learned Tribunal under the IMDT Act by judgment dated 23/12/2002 in case number IMDT/H /290/D declared the petitioners to be illegal migrants who had illegally entered into the territory of Assam after 1971. Is satisfied with the said opinion, the said judgment of the opinion by the date 23/12/2002 passed by tribunal. दिन पे टाइम ये अगर देखिए ट्राइब्यूनल होता है संकट में the petitioners preferred a read petition being WPC number 7093/2003. No. Preferred an appeal.
Miss case 35 of
Right.
2003.
Before the appellate tribunal at Guwahati as provided under the IMDT Act. Right. Being this case number 35/2003. The said tribunal, sorry, said appellate tribunal by an order dated 31/07/2003 dismissed the said appeal being time barred, preferred by the petition, being time barred. As such, those petition for deleted against both the orders passed by the tribunal as well as the appellate tribunal. After hearing the parties, a single judge by an order dated 11/11/2003 in WPC number 7093/2003 quashed both the orders, i.e. the judgment and order dated 23/12/2002 passed by the IMDT Hotel, Raidiga, as well as the judgment and order dated 31/07/2003 passed by the appellate tribunal. Noted above. Directing the concerned appellate tribunal to hear the appeal on merit, condoning the delay in preferring the said appeal number such, with further observation that the petitioners shall not be deported till disposal of such appeal by the appellate tribunal. We'll make a IMDT for it. It is to be noted herein that by judgment in order dated 12/07/2005 in WPC number 131/2000, the Honorable Apex Court, in the case of Sarbananda Sonowal versus Union of India, within bracket 1 lecture, reported in 2005, 5 SCC 665, set aside the IMDT Act and struck down the IMDT Act and issued the following directions at para 84 of the said judgment. 84. Number 7093/2003. Preferred this writ petition on 23/07/2019. Paying amongst others for a direction to the Foreigners Tribunal, Hojai, to take their matter for fresh adjudication in terms of the order is that 11/11/2003 passed in WPC number. On being inquired, Ms. A. Verma, Standing Counsel, Home Department, Assam, on obtaining necessary written communication from the Foreigners Tribunal, Hojai, submitted that after the order of the court dated 11/11/2003 passed in WPC number 7093/2003, the petitioners did not approach the said tribunal at any point of time nor the said tribunal received a copy of the said order dated 11/11/2003 passed in WPC. On being inquired, the registry has also informed by its note dated 26/02/2024 that the said order dated 11/11/2003 passed in WPC number 7093/2003 was not communicated to the appellate tribunal of the liability. Was not communicated as directed in the said order dated 11/11/2003. The state government after the order of the Honorable Apex Court in the case of Surperson noted above, instructing down the IMDT Act, constituted relevant foreigners, state community, and being notified by the Union of India and the Ministry of Home Affairs dated 26/07/2005, published in the Gazette of India 26/07/2005. Regarding the informed that the tribunals and the appellate tribunal constituted under the IMDT Act 1983 ceased to function in view of the order of the Honorable Apex Court in the case of Bradley. Thereafter, the state government by its notifications constituted respective foreigners tribunal. By notification dated 24/01/2006. And those cases which are pending for consideration before the tribunals under the IMDT Act as well as the appellate authority was transferred or were transferred to the concerned foreigners tribunal constituted under the Foreigners Act 1946. Considering the Superintendent of Police Order is now directed to place the matter of the petitioners pertaining to IMDT/H/290/90 before the Foreigners Tribunal, Ojai, at Sankatev Nagar, Portrait. For an appropriate opinion as to whether the petitioners are foreigners under the Foreigners Act 1946 or not. The petitioners shall appear before the Foreigners Tribunal, Ojai at Sankatev Nagar, along with a certified copy of this order on or before 15th of March.
I have a submission, Lordship, since there is already a reference against the petitioners. Their voting rights should be curtailed because they're voting from 1997, Lordship. That is at Annexure 7, page 28.
The earlier order of the tribunal of the court
Yes,
set
Lord.
aside would the order. So in that case, as on date, they are not considered to be a foreigner.
Lordship can make
That
us
order of
observe
11/11,
1111, Lordship.
both the orders of the tribunal as well the appellate authority are set aside.
A small observation can
How
always
can
be
we
made
do it? After
because they
such
have
as-
voters, thing list up to 2014, even 16. Lordship.
True, but that order passed by the earlier bench of this court on 11/11/2003. The IMDT orders passed by the tribunal as well the appellate tribunal, etc. So since then, how do you will continue, how do you count him as a foreigner? And whatever stream may be, put the orders, it's very much there, it's there in the copy of.
In fact, madam, you may be right, because the initial order of the tribunal was against the petitioner.
Against the father.
Against the petitioner,
so-
they preferred an appeal.
Yes.
Appeal was time-barred. Appeal was rejected. The main grounds of challenge in the writ petition was the order in the appellate authority, because the appellate authority is vested with the powers to look into the correctness of a tribunal. Now, if you see the first part of the order, first paragraph,
That was the influence order.
then see the second, after hearing the learned counsel of the parties, court in the right petitions shall be given an opportunity to correct the defects in the memo of appeal. So the court was concerned and only dealing with the order of the appellate authority. But
Yeah.
in the penultimate paragraph, both the tribunal's order as well as appellate authority's order have been satisfied. So that means as on today, there is no opinion against the petition.
Fresh proceeding, not to,
But
that too after
whether
inquiry now.
after
Yes.
the main order has been set aside, what will the, in a given case, what will the appellate authority do? There is no order.
So
Otherwise also,
Lordship has directed for a fresh inquiry.
not entered. That
Reference.
opinion, that
Reference,
reference,
fresh reference,
not
yes.
fresh. The SP holder will
Fresh
place it
proceeding,
before he now furnace trial,
Furnace side, not the IMDT.
not the,
IMDT is gone, Lord.
before the furnace tribunal under the 1946. Tell it, yes, sir. Registry self forward. Copy of this order and the superintendent of police order. And the letter, the furnace. They order the obligement.
Major rally. It's represented this pattern. What's happened?
Report to call police.
He report
Regarding the mental,
mental.
our case is like he is insane, he become insane.
Hmm?
Mental
Let's
illness.
it's addition. I'm writing on online.
Actually,
Ask them. After it was a mental state. I think it's also once. I remember.
your lordship, in this case, your lordship, my basic case is that after proceeding initiated against me, I have filed WS and thereafter I become insane, mentally ill. And I have also submitted the document you order wherein the report was called for in this case, your lordship, regarding my mental health.
Yes, and I'm not a type of. Thank you, Dijo.
I have to be like this.
70 megabit report is set to your initial and final. It will be here. Updates.
No, what happened after this order? Because there is an order last passed again in consideration of the petitioner about his mental health. The order was first on 17/11.
1711. Yeah, lot.
It was also supplied to Mr. G. Sharma. Burua.
Latest report আছে জানো ফোনে সব latest report আছে that is good. How many mental hospital
Report has come. Oh, yeah.
ये 18 का है, पहले वाला।
ये पुराना वाला, नया वाला।
So there is a recent report that your mental, your condition is okay, improved.
My
That is the
inspection,
report latest of December.
your loss, isn't,
2018, there are two reports whereby your cooperation was not there. It has been reported.
yeah,
But now thereafter in 2023, we can read it out. He was diagnosed to have psychotic illness along with mild intellectual disability, and treatment was initiated accordingly. As he showed clinical improvement, he was discharged on 16/12/2023. We'd advise to continue regular medication and periodic follow-up.
the improvement is there, your honor. Totally he is not cured.
No, but improvement means his discharge means
But,
obviously medication needs to be continued.
your honor, to what extent he is able, now in a position to fight the case, your honor? Because it's a serious case, you have to tender evidence.
What is your age?
In 2018, your lordship 35. Forty, 41, your lordship.
What is your prayer in the reparation?
Your honor, what when in this case, your after when I detected that he is ill, I file a read petition, your lordship. It is item number 12, wherein I challenge, I file application before the tribunal stating that he is mentally ill, and that petition was rejected. Thereafter, I come up with an read petition before your lordships, item number 12, wherein your lordships order are passed for his examinations. But when I said to the tribunal regarding this, your honor, in fact, we have not produced the order. Ultimately, it is proceeded and opinion was granted, against which I come up with this item number 11, now the final. My, as of your honor, in the first read petition, for satisfy this, your lordship, the opinion handed over to me.
What was the stage when you had filed the application for informing about your mental health
That was the
evidence stage?
your lordship. I have already filed my WS document and evidence, your lordship.
You had filed your evidence,
WS.
WS,
Yeah.
evidence was yet to be filed.
Yet to be filed. In fact, it was proceeded ex parte and ultimately
Did you file the documents also
document I have not filed, your honor.
along with the WS?
Your lordship, as per my record, your lordship, you are not filed.
Not filed. Documents that were- Yes, when can you file the documents?
Before the trial of your lordship.
In the case, we intend to interfere with the ex parte order
As your lordship, direct your lordship,
within 10 days.
not 10 days, your lordship. Because
These are old
your
matters.
lordship, my humble submission, how far he's improved.
No, see, you do not have the instructions. We have got the instructions. written
Your lordship,
instructions.
your lordship.
Thereafter,
So-
you're making a submission on your part, that will not look good.
My only submission is how far he improved, the report is before your lordship.
This report is there. We'll
Your
go with the
lordship.
report.
So your lordship, he's in the stage of improvement, reasonable time may be granted to me, your lordship, for,
You file the documents, then the tribunal will give a date for evidence cross-examination.
your lordship, a reasonable time maybe.
Item 11, lordship, an ex parte order has been passed against him.
No, that he has already disclosed.
Yes,
There are two writ petitions. One
Yes.
is against the rejection of the application to defer the proceedings because he is not mentally fit.
yes.
And the other that the tribunal went ahead and had given an ex
Passed
parte
an
order.
order. Yes, Lord.
An order which he terms to be an ex parte.
Your lordship.
Since the initial reports, the indeed indicated regarding the mental health of the petitioner, which now of course has improved, and in the meantime, sufficient time has passed. He is not a very aged person.
Not,
Ms.
they're
Verma.
quite young.
The WPC 1533,
Yes, lordship.
page number 30.
Order 30.
Against the page number 30. Against the rejection of the said order, the tribunal was informed regarding his mental health,
Mental health.
but that petition was rejected. Against this writ petition, 153.
Yes, lordship.
Thereafter, an ex parte order was passed. And against this, the next expedition, 2051. Right? Okay. Third, which was the both these repetitions being connected are being disposed of by this common order. Para. The petitioner was a proceeding in FT case number so and so, before the 20. As per the projected case of the petitioner, after filing of the written statement, an application was filed before the learned tribunal, whereby it was informed that the petitioner was suffering from mental health ailment, and accordingly, a prayer was made to defer the proceedings. Full stop. The aforesaid petition was, however, rejected by the learned tribunal by an order dated 7/2/2018, and the said rejection is the subject matter of the first writ petition, WPC 1533 of 2018. Full stop. Para. In the meantime, the tribunal went ahead with the proceedings and disposed of the same by a final opinion dated 21/3/2018, whereby it was opined that the petitioner was a foreigner, illegal migrant, and consequential direction was given. Full stop. The state opinion dated
21/3/2018 is the subject matter of the second writ petition, WPC 2051 of 2018. Full stop. Sarah. During the course of the proceedings, comma, instructions were sought for by this court, and in this regard, comma, written communications received by the learned telling counsel were handed over, were placed on record. Full stop. The said communications, which are of the year 2018, had indicated that on examination, the petitioner was found to be conscious, alert, and cooperative. And only his mood was found to be depressed. Full stop. It was also stated that there has been irregular past psychiatric treatment, and accordingly, further evaluation was advised. The report also indicates that due to non-cooperation of the petitioner, comma, further assessment process could not be completed by the clinical psychologist. After filing of the second writ petition, WPC 2051 of 2018, comma, this court had called for a fresh report from the concerned authorities. Accordingly, comma, a report dated 2012-2023 has been furnished, as per which, comma, the petitioner was found to have clinically improved and was discharged on 16/12/2023 with advice to continue regular medication and periodic follow-up. Full stop. Para, we have noted that the present age of the petitioner would be around 41 years. Full stop. Para. After consideration of the materials on record, particularly the written instructions which were obtained from the concerned authorities, comma, we are of the opinion that at the relevant point of time, comma, the petitioner, it appears that the petitioner had some mental ailment for which he was not able to defend himself properly. Full stop. The earlier reports of 2018, the said reports were, however, of the year 2018. Full stop. The recent report of 2012-2023, however, has stated regarding the clinical improvement of the petitioner and the fact of his discharge from the discharge on 16/12/2023. Full stop. Taking the aforesaid facts and circumstances into consideration, comma, we are of the opinion that interest of justice would be served if the ex parte opinion, if a proper opportunity is granted to the petitioner to defend himself in the aforesaid FT case. Full stop. Accordingly, the ex parte order dated 21/3/2018 passed by the learned so-and-so tribunal in FT case number so-and-so is set aside. Full stop. Since the petitioner had participated to the stage of filing of written statement and no documents were also filed, comma, we direct the petitioner to appear before the learned tribunal on or before
20 days, yeah, actually.
today is on or before 15th of March 2024 to file the documents as well as the evidence on affidavit. Full stop. On such appearance, comma, the learned tribunal would take charge of the proceedings and proceed strictly in accordance with law. Full stop. Let a copy of this order along with a copy of this order be transmitted to the learned tribunal for doing the needful in terms of the directions made in this order.
Much obliged.
Both the petitions accordingly stand disposed of. The the interim order, if any, stands merged with the final order, with this final order. The communications made to this court, communications of the authorities regarding the health condition of the petitioner, which were placed on record, are made, which were placed before us, are made part of the record.
Much obliged.
Made physiological. My lord, it's an ex parte order. I appeared, my lord, and I filed my written statement also. Thereafter, the proceedee did not appear. She lost her husband and she left for, as per my instruction, my lord, she left for livelihood to Kerala in search of livelihood. Thereafter, she came back and filed a one review petition also, stating that give me some time, I'll adduce my evidence. That was rejected. And we have annexed the document showing that my father is a voter in the 1965 voter list. This is the case in a nutshell. Had we been given a opportunity to prove our case, that I could produce the document that my father is a citizen of India of 1965 voter list. And there are some linkage document too.
Somehow, first, we are not too much convinced with the reasons which you are citing for not contesting the case.
My lord.
Those cannot be grounds. Grounds have to be sufficient, reasonable, acceptable. But to prima facie show, make out a case. What are the documents?
Documents, my lord, that I am being instructed to show to your lordship is that the voter list of 1965 that shows the
Page.
page, my lord, which vernacular is at, my lord, annexure 1, page 8.
Yes.
This is,
What is the name of your father?
yes, Lukman Ali, the
And
first one.
What is your link?
That linkage document I am not provided with, my lord. But this is my father, and thereafter also my name appeared where my father's name shows.
Where?
No, when in my voter list, my husband name is,
No, your link with his father. Prima facie to make out a case.
my lord. That's correct, my lord. But since I have not been provided with this document, but my respectful submission would be, my lord, since our prima facie claim that Lukman Ali is her
No, prima
husband.
facie show us. You say prima facie will not do. To come to a prima facie satisfaction, there has to be some document, though we are not supposed
My
to
lord-
look into documents which are not.
My lord, may I pray for something, my lord, a limited accommodation. If kindly give me some time, I'll take instruction on this point and I'll file a written addition.
Sorry, Mr. Chamwa, it didn't matter. You're praying for time to file a document.
No, my lord, this queries, my lord, just have your
What is
lordship has
this-
raised.
What is this query? Is this query irrelevant?
No, it's a really.
This is the only query we'll put to you.
No, my lord,
First, we are
let's-
not even supposed to look into documents.
no, my lord, I bow
Which
down
are
to
not
your,
before the tribunal.
no, I bow
Now,
down to your
would you-
lordships.
For the sake of justice, let us have a look at the document. There is not even a single document.
No,
Show
my
us a
lord,
document linking with your father.
I bow down to your lordships, my lord.
What would be the outcome of a remand, if which you are praying for?
My lord, that is why I'll,
What is the outcome?
my lord will fix it on the next week, my lord. I'll come up with documents. My lord. If there is no document, then also I will come up and will say to your lordship that there is nothing. Last opportunity,
If
my
it did
lord,
not
this will,
occur to you from 2018 to 2024, we are not going to grant you time. Sorry. Can you tell us when you have filed a written statement?
my lord, written statement was filed on 17/4/2009. এই অসমীয়া এনেকুৱা copy এটা আছে। I have annexed that.
After the notice from the order.
Mhm. In 66.
In your written statement that you have filed before the tribunal, have you stated about the name of your father? Who is your father? Who is your mother?
There on record.
Can you show us the name of your father in your written statement? Mayor making a statement. that
My lord,
somebody
there is a additional affidavit where I have annexed my written statement.
From
that-
there only we are asking you. Show us the name of your father in your written statement.
Name is not mentioned, my lord.
So-
I'm helpless on this
Just
point.
mayor making a statement that name of your father
exists in a voter list, will that?
Then I
do?
cannot improve upon because it was filed there like this.
So that is the reason.
My lord, one more thing, my lord, if lordship can see at page 18 of the opinion of the learned member of the tribunal, the last paragraph, it says, when I therefore give my opinion that the respondent Musammat Malika Khatun, wife of Saiful Haq, is a foreigner from erstwhile East Pakistan.
Before that, you will just see, because she failed to discharge her mandatory burden under section 9. of the
I
Constitution.
understand, my lord.
So-
I understand that, my lord, but since it is the stream of 1966 to 71, so I may apply for even registration also. There is one
There-
more
Is
scope
there
is
any
there.
bar? You could have applied immediately.
No, I understand, my lord. Now, my difficulty is that I cannot improve upon whatever I have been given.
See, you don't have an alternative prayer also that
Yes,
even if you are satisfied or maybe you are not challenging the impugned opinion, then you may be allowed to register. That is not your case. You are challenging the opinion without any condition, without any.
my basic prayer was for a remand, my lord, so that I can adduce my evidence there and after that, if the tribunal find, my lord, that I am a foreigner
And
or,
you know that the time for registration is also a limited time. It's a prescribed time. This
180
opinion, this opinion is of which year? 2018, I think.
18.
11 opinion.
2000
11 or opinion.
11 or open. That's what.
11.
And you had filed this writ petition after 2000, after 7 years. 2018. There is an order of this court at page of or dated 23/5/2018 when you had filed this. While prima facie we are not inclined to entertain such writ petition filed belatedly, we find that in the order it is mentioned petition and filed written statement. Such petition has not been annexed, so we would like to peruse the written statement, which you have done by way of additional affidavit. You have seen it.
Mr. Resuma for the petition, in liquid. It's not. 7. For pronouncement of the word.
my lord, fix it on.
We'll pass order on 7th. We'll pass the necessary order on 7th.
My lord,
For pronouncement of order we have kept.
my lord.
Yes, my lord. My lord, Mr. Rupak Dhar is available in this case, my lord. He has his younger brother expired yesterday, my lord. Suddenly he left for Coachbihar, my lord, and file is with him, my lord. Matter may be taken after 2 weeks, my lord.
Notice in this case was issued on 28/05/2018. The record of FT NAL in bracket, MMA. Case number 205/2016 was called for from the Foreigners Tribunal number 3, Almari at Mukalma. Office notes reflect that the relevant record, it was also dated to 12/2020. The said record has not yet been received by the registry. Issue reminded the said record from the Foreigners Tribunal number 3 in Almari. The registry shall also inform the Superintendent Board Nalbari. Pertaining to record of the. For the Standing Council Home Department. Shall also apprise the concerned foreigner tribunal number 36 as well as Superintendent Police Board. List on. Fourteenth of March.
Obliged.
Lordship, copy of this order will be.
Copy to MSP.
Well, the records were requisitioned through the office. But you can use your good office to.
XPG,
But
Lord.
on the same that you have to tell us whether the petitioner appeared before the Superintendent Police Board of pursuant to the order of the court of.
There's an interim order.
28th of May 2018. You have to tell us.
May please, sir.
Instruction.
Yes.
May
Yes.
please, your lordship. Lordship, morning time, my lord, this matter pass over for the day, my
Which
lord.
one?
This matter, my lord.
That is why you have called for.
Yes,
We
my
have
lord.
not passed any order on that.
My lord, this is case, my lord, Elsar was called for, my lord, Elsar must have been not received, my lord.
Same order. I'll go to click it. We need to click. The petitioner selected the court as 220 APS for the Superintendent Police Board. Null. Same order here, only case number will be FTDC, will make it 6198, Foreigners Tribunal, number 7, Tezpur, Sutia Hogan, now at Bishanath. Superintendent Police Border, Tezpur is the Superintendent Police Border, Bishanath. I go to Kalin already, it is Superintendent Border, right? Copy. Might be, records might have been transferred to the Superintendent Police Border, Bishanath now. Placed on same date. I got it. On the say that petitioner shall apprise the court as 220 APS. It is given already. Pursuant to the order, it is 30/05/2018.
Blessed.
Ali, 19. Yeah. Give me-
Ms. Verma,
Yes, Lordship.
this is with regard to that marking D, but no proceeding has been initiated. That way we cannot keep a person like D
Yes,
unless you
Lord.
refer them for the,
So it has to be sent back to the.
get the instruction because there is an order earlier. That order was of, no petitioner on the last 2 occasions did not appear. There's a specific direction to Mr. Ali
Ali.
by the court. That was in 2018. Whether the election commission has referred the matter to the Foreigners Tribunal or not. You just cannot keep a person as a D voter, right, doubtful voter,
Yes.
unless you initiate the procedure. Let us know, because
Comes up for the single bench judgment. When the direction is issued by this court to refer the direction.
it is there, but later, because there is a specific direction by the court.
Yes, sir, I'll obtain it.
When? Tell us. Sixth or seventh? On the prayer of Mr. A I Ali, standing for election.
May I please, your lordship? By order date 1/6/2018, LCR was called for. my lord.
So much. Huh? FD, you didn't make it no, case number and file over case number. Notice 1/6/2018.
File nine.
Office note dated. It is now, so,
No, file nine.
12/2024.
Same order. Can they appear about one and the third?
Same, we are keeping it on 7th
Second,
or 7th.
oblige,
You take instructions when you had appeared.
lordship,
7 is still 14th. Or 14th. 14th.
14,
Records today.
oblige.
Same copy to everyone.
Yes, that's correct. LCR was called for, my lord, by order dated 13/6/2018, my lord.
The number,
21. File to one, I think.
file amount to nine,
Same order.
same order.
FT case number 100 of 2017. From the Foreigners Tribunal, Kamruk Metro number 21. Notice usually 13/6/2018. Office note 2/12/2023. Remainder provided. Stated select. Inform as to open. Okay.
Lordship, a copy of this writ
All these,
petition,
you'll get a
no, copy of this writ petition, he also does not have, our file is also missing. They pray for a copy from the court.
Officially, we cannot pass that on.
You
Yes.
apply for a copy,
We get to the Xerox, lordship.
from him you get a copy.
No?
From him.
He's lost his file. Copy. आधा कोई खुशी। अरे वो जो है कि लास्ट को वर्जन से देखो।
Okay, 6/11/2023. No, notice 05/05/2007. Records of application number 350/2007. Foreigners Tribunal, Past Morino. Office note 17/11/2020. What's your good name?
V. Satya. We have a Emir Mahmood.
Same day. Huh? Okay. That's to when appear with the private. Copy to her. Me too. You are in this. Ah, notice to correlate. Notice to 712.
এইটুকু ছোট ছোট আর কি। কমে না পড়ে পড়ে বলে। আমাকে কফি দিব কইছে। কফি কিন্তু কি হবে দেখতে হবে। একটু ইন্টারেস্টিং ডে। নাইন তোমার 11 ওতে রেজিস্টার করলো তো সাজিলো রেজিস্টার করলো।
2011. Oh, sorry, tomorrow. Mainly after 2017. After the whole, if you take it, and then you do Yes, what do you have to say? An opinion of 2011,
Yes,
Prosody was
Lordship.
declared to be a foreigner of 66 to 71 street.
Approach
She
this.
did not register, but she
Never
continued to vote. What actions you have taken?
Non,
So there is no stay order from the court.
there are
We allow, right? We allow the petitioner to
register.
get all the benefits. Your department.
Yes, Lordship. One miscommunication and non-coordination of the department's Lordship. Just a five. Hmm? कोई दियो तो कोई दियो कार कथा कोई दियो हाँ कार कथा करते हो every way but not in the लेकिन अन्य का मिसकंसेप्शन हुए से सुप्रीम कोर्ट जजमेंट न हुआ लोग की जाके काम इलेक्शन और आगे तो नहीं
What do you have to say?
Lordship, my submission would be that the petitioner has not gone on time, Lordship, for the registration despite the order of 2011 and approaching this court in 2017. And now it's 24, Lordship. She has all the provisions are also not working for her there.
No, we are just thinking about this kind of situation. At 66 to 71. One is required to register himself or herself.
Yes, Lordship.
Time is prescribed 180 days. He or she doesn't do. But the opinion is not under challenge.
Yes.
He or she is satisfied with the opinion. Okay, I'll not vote for 10 years. But in the meantime, he does not get himself or herself registered.
Hmm.
So according to you, what should be done in this kind of cases? Suppose we reject this writ petition, then what will happen?
Then he is a foreigner, Lordship.
Of that stream,
That stream.
what difference will it make?
There is a
From the date of registration, voting rights are not there till 10 years.
10 years.
He has already voted for more than 10 years now. Now, even if he registers tomorrow, next 10 years perhaps he will not be able to vote.
Hmm.
But opinion as such is not the subject matter of challenge. Rejecting this application, what will be the consequence? He remains normally he keeps on voting.
Keeps on voting, Lordship. Until in one would be filed.
And Madam and Mr. Payang also, if one does not register, what is the consequence in the act?
He will be declared foreigner, but
Huh?
foreigner. He will be deported. If we didn't.
If it doesn't,
Yes,
okay,
madam,
that
we
is there. From 2011 to 2016-18, did you take any step for deporting him?
No, we haven't taken. No.
Deporting her? So the statute will not leave a blank like this. It cannot be vague. If one does not register, it cannot be let no consequence. Definitely there will be consequence. You could have gone ahead with the consequence. What ground do you like? The reasons which you had cited for not getting yourself registered have been prima facie held to be not acceptable by this court. Four grounds. But even then, the court said that let us give you an opportunity. The order is very specific. All the four grounds which you have cited have been considered, and the court has given in a very harsh language. Grounds have been found to be ridiculous. That is the language. Madam, after section 19. Rule 19. Of the 2009 rule.
Citizenship. 2009 citizenship rules. Yes.
The proviso to 2A, 19(2)(a).
Yes.
This was inserted later in the year 2013. 2A gives the power to extend. But what is the consequence of not registering? And the power to extend is also not unlimited. It is limited to 180 days. Of the rules or sections, act.
Yes, yes. Hmm. Is 160. Hmm. Without respect to the provisions of 63. If any person required to take the subject manner and form and respect the within 60 days from the date of application to the commencement of the citizenship or in a that does not give to the citizen of India. Thus, person does not give to the citizen of India under the provision. 174. 174.
Which provision are you reading? 6A. 6A6. Yes.
Also registered under subsection P, then we need to be citizen of India. If it is registered under this subsection P, we need to be citizen of India. As from the date of expiry of the period of 10 years, from the date on which he has been detected to be foreigner.
Yes.
Then, my lord, 6, my lord. Without prejudice to the provision of section 8, my lord. A, if any person referred to subsection 2 submits in the prescribed manner and form and to the prescribed authority within 60 days from the date of commencement of the Citizenship Act 1985 for year of declaration that this is in case of he does not wish to become citizen of India, such person shall not be deemed to be have become a citizen of India under this subsection. That is in case of application. If any person referred to subsection 3 submits in the prescribed manner and form and the prescribed authority within 60 days from the date of commencement of the Citizenship Act 1985 for a year from the date of which he has been detected to be foreigner, whichever is later, a declaration that he does not wish to govern by the provision of that section 4 and it shall not be necessary for such person to register himself under section. This is
And you go Bhopal, if you do not register, that means you're not willing to be a citizen. It can be construed that way. No? Then they can keep it.
Purvich. 19 is
Appendix for the two. Now, how is it relevant? 6A is different. If he doesn't wish to register.
If he doesn't apply, if he make an application that he doesn't want to register, then
Now, what is the meaning 4-year? What is the meaning of this 4-year? Please read again. A,
6A5,
6, the subsection 6 is,
A5,
and A thereafter. Without prejudice to the provisions of section 8.
the provision of section 8. If any person referred to subsection 2,
2 means the 66, that
मतलब
stream.
6A2 मान,
6A2 is the 66.
yes, 66 to 71.
Yes, yes.
If any person referred to subsection, something to prescribed manner and form, and to be prescribed authority, it is property to constitution of the penalty by 90 for a year,
Not for a year. For a year, a declaration. What is
for a
this?
year a declaration, that he does not.
I think there is some printing error here. मेरे कैसे नहीं करते वो इधर? एक और बार। I think that is no, not making any sense. Here, here. For a year to here, here to here. I think here has been somehow not making any sense for a declaration. For a year, a declaration. For a year, declaration that we have here for a declaration. Here, 25. So, this is for which to within if 3% effort to A. Until 1989, year, year to 9. I think year has been wrongly been interpreted. It doesn't make any sense for a declaration.
This is what matter, this provision says, if he doesn't wish to register himself, if you make an application.
Declaration. That I don't want to become a citizen. Then if he doesn't do that, that is for one who doesn't want oneself to be a given the benefit or whatever under 66 that stream. Then but what is the consequence laid down if one does not register?
The person shall not be deemed to have become citizen of India. So, same way, my lord, the section 6(a)(2) and 3 doesn't provide citizenship. It provides, my lord, need to be citizen of India on registry. So, if he is not a citizen, he will be, my lord, under Foreigners Act, he will have to be deported. 46. Section 6 doesn't provide this deportation. Protection given to the 13 class of citizens. For it, for to cut the form. I can notification, get it notification. Here, not here to 1985 or what. For yeah, it is a declaration, follow me. So, for year to Kishore section order, you can copy for it, a declaration. Command. 1985% comma eta. Next to B. For year. For year. No, PDP. If any person referred to in subsection 3 commits the and from and to the specified it is to the if one goes it is not or from the date on then প্রথম তো না প্রথম তো এই declaration second to এখন মতে or from the date on which he has been declared or figure with for year নাই না এটাতে গ্রুপে ground Mr. Pang, notice in this case was issued long back. January 2018. Sorry. Placed on 12th of March. In the meanwhile, the respondents self-filed their respective affidavits on or before 11th of March without fail. Pursuant to the order of the court dated. You can write it. Notice in this case was issued on 19/01/2018. The respondents are yet to file their affidavit. List on the film which court shall consider to first consequence.
Yeah, please, Your Lordship. Lordship, in this matter, we have received a reply filed by respondent number 2, 3, and 5. So we need some more time to go through this affidavit, Your Lordship.
It is there on the record. What have you stated in your affidavit, Mr. Khan? That is it. What has happened?
On that thing, because even a third preparation. But the five. On 18/20. On 18/2021 at about 12 p.m. the October located in 24 stores of information and class members Ayurveda and Bhakti and brought a complaint from glass and when pending his narcotic substances for further investigation at their house. Accordingly, Uti control trace this is field staff located at their house. At about 1 a.m. when the police came into the house, they found the exhibit along with the accomplice sitting around something and discussing. This Patwal here announced his identity and asked them not to move. Khairul was sitting with his back towards the Otis Patwal here suggested Vatam and swung it quickly towards him. He kept moving towards him wildly swinging the quickly towards him, targeting his neck and head and with the intention to kill him. Khairul kept attacking repeatedly and in order to save himself quickly, followed Dr. Gupta instinctively raised his hand and got slapped on his left arm by the police. This led to a scuffle on the other accomplice of Khairul Islam also made use to attack the public Gupta. I will have one hand on the officer's neck and was keeping him back by taking the complete one as I followed Dr. Gupta's head at that time. Seeing the officer injured and almost overpowered, the driver was jumping to save him from the deadly attack. Sensing that the situation to be turning worse and fearing that he might be killed. SI Dr. Gupta drew out his official pistol and fired in private defense with the pistol, as well as the driver from the forces did an attack of federal establishment. And in that, good night. Firing, the firing include firing from that was injured and profusely bleeding. He along with the injured men were immediately shifted to BP station hospital. Noma and Bharat to the Hospital were BP attended. All of them. The bullet lost was taken by one where still, however, medical research was there at it.
Let us see the injury on Mr. Alok Gupta. Where is the report? Okay. Is the
Page 44.
What about the driver?
Next week. Football board. Page 45.
Mr. Chakma, you want to file reply?
Yes, your lordship.
Okay.
And
You file your response to this.
Yeah.
File it by 11, on or before 11,
11 March.
list on 14.
Lordship. Lordship. Can it be on 15th or 19th? Right. What is the code?
Okay, on 19.
19th. Lordship.
The respondent numbers 2, 3, and 5, represented by Sri D. Nath, the senior law advocate, have filed an affidavit on 22/2/2024, which is on record, full stop, para. Sri Chakma, the learned counsel for the petitioner, prays for some time to obtain instruction
let's file affidavit in reply. Put the para as paid for list on
19th.
19 March 2024, prior to his date, comma, the reply affidavit is required to be filed.
Deputy Ombudsman.
Next. Next. What is the next?
Deputy Ombudsman.
Item 45.
May I please your lordship? In our WPC number. For time extension. 24/8/2023. No, for 20 years it is directed here. Other person for 4/8.
What happened to you, madam?
Your Honor, the petitioner. The
Use
petitioner.
the microphone.
Hmm?
Switch on the microphone.
The petitioner was ill at that time, Your Honor. She is suffering from jaundice. So
When did you apply for or get the certified copy of the order?
we on 7 on 7/8
7 what? 7
7
August.
8 2023.
When was the date?
Date of appearance is 28/8/2023. Lordship.
You got the certified copy on 7.
Lordship.
The date of appearance was 28/8. 20 clear days were there. What is the statement regarding your jaundice? Where are the papers, medical papers?
She's at rural, she's living in rural area, Lordship. So
Rural area, there is no medical.
no, she's very poor actually, and in village areas.
For poor,
there
there
is-
is no medical.
No, in village areas, for if someone suffering from jaundice, they will go to like village quack and all.
Village quack, what is quack?
Like in village areas, like oh, some ladies are there, now ladies or them.
Do you use this expression quack in a positive sense?
Yes, your lordship.
Positive sense. Do you know what is the meaning of a quack?
No, village quack means lordship like
What is a quack?
quack
What kind of expression you are using? And that too in a positive sense. You said on your own that you were treated by a village quack.
Yeah.
What is the meaning of quack?
Village quack lordship, mane
Lordship is asking you what is the meaning of quack?
only quack.
Whom do you call quack?
Okay.
To whom?
Can you use the expression quack in the positive sense?
No. Okay.
And you filed this application when? In October.
October lordship. Actually, the petitioner is suffering from jaundice and she is very ill to come to her council lordship.
When did you suffer from jaundice?
from,
When?
from the month of July, Lordship.
Month of July.
Yeah, Lordship.
Where have you stated?
He has not stated Lordship, but at
You
that
don't
time
state-
she is suffering
you
from
don't
jaundice. He has stated like this.
See, the application is filed by you. You have to state all facts. If you don't state something, we cannot assume anything. You are not, there is no restraint of stating all the facts. Rather, you should disclose all the facts. You have not stated anything. Not a medical paper. When did you suffer jaundice? Whom did you consult? Nothing.
Lordship, actually in village areas, in remote areas, now if
You tell us a
someone,
remote area in Assam where you don't get the facility of medical. Tell us.
no Lordship, for all, there is medical facilities, but for jaundice and like this kind of disease now,
Okay, when did you go? When did you suffer? That much you have to state. Even if you accept your version, that you don't, you need to go to a medical practitioner, there are village people who will cure you. Okay, let us assume that is correct. When did you go? When did you suffer? When did you get well?
Your Honor, one opportunity may be given to the petitioner to appear before the tribunal, Your Lordship.
Your conduct is not inspiring any, does not inspire confidence.
One final opportunity, Lordship.
Reference is of the year 2016. Opinion is of 19. The High Court's order remanding is of August 2023, giving you time till 28th.
The delay is not intentional, Lordship. Final opportunity may be given to the petitioner.
Yes, Ms. Verma.
Lordship, the petitioner is not serious about. Even after having an order in her favor, she has not approached the court. And citing about her illness also is very vague, Lordship. Just one paragraph saying that she had some jaundice, and that's all. And jaundice was also, she said in the month of July, she had jaundice. But this order was passed in August.
August,
August,
it takes some time.
Yeah, it will take 3 months.
Done.
to address the court.
No, that has not been stated also.
Nothing has been stated, Lordship.
Lordship. We apologize for the delay, Lordship. One final opportunity may be given.
The opportunities have been always granted, Lordship, but they do not honor the court's order.
It is not intentional, Lordship.
What's your good name?
A. Hussein.
Lordship, even if Lordship intends to remand it back, Lordship will impose some cost so that it doesn't happen again.
She is a very poor lady, Lordship.
You are. Now, in Fairness Tribunal, Buxar, Ramanpur, in Africa by opinion and order, dated 25/02/2019, in Africa case number 2698, public Buxar of 2016, declared the petitioner to be a foreigner under the Foreigners Act 1946. Agree with the same. The applicant as a petitioner. Comprehensive petitioner. Agree with the same. The applicant, the petitioner, preferred the connected rate petition WPC number 5825 of 2019. Coordinated bench of this court by order dated 15 04/08/2023. Remanded that say the FP case number such and such. The Fairness Tribunal such and such. For passing a fresh order. Considering the or examining the voter list of 1966 and 1970, as well as the Jamabindi in favor of the applicant. Directing further the applicant to appear before the said tribunal on or before 28/08/2023. But the said order dated 04/08/2023. The court also directed that in the event reason order is passed in favor of the applicant plus petitioner, it shall prevail over the earlier order of the tribunal dated 25/06/2019. And if it is against her, then consequential action shall follow. By this interlocutory application, the applicant submitted that she suffered from jaundice since 28/08/2023 and as such failed to appear before the foreigners tribunal concerned as directed earlier by the court on 04/08/2023. First in WPC number 5825 of April. Not appear before the tribunal of 28th. Answer this application by the applicant, praying for extension of time for her appearance before the furnace tribunal of Stockholm pursuant to the order dated 4/8/2023. First in WPC number. To the submission of the petitioner. The grounds taken by her appearing before the tribunal on 28/08/2023 found not convincing. But considering entire respective matters and for compliance of the order 4/8/2023 percent of the petition. Direct the petition of applicant the great petition. WPC number 5825/2019 to appear before such and such tribunal by sorry. Or 11. 12 of March 2024. Okay. 12 of March 2020. However, it is not clear that it also shall not be considered.
Deeply obliged also.
We have to put it,
Matrix. In this case, yesterday I mentioned your lordship that the petitioner of your lordship, after filing this IA, he was suffering from some.
we are considering the entire matter.
And my lord. And in this case, I received notice from the tribunal. I filed my written statement. And then I deposed. And one of my brother, deposed. It is a bit. And I'm not. Some land certificate is there, that is on record. And voter list was given me in 1965 of my father and mother of village Alengmari. And then in 1970, father and mother of Alengmari. And then in the petitioner and petitioner husband, he is a woman Miller. Voter list 1994. Yes. And again, father was in 1997, there Miller in Villa Alengmari. Father had some land Miller. Yes, there is there Miller. That Jawabandi, that is also annexed G is 31. First Miller, the Russian may kindly see my release statement. And petitioner Miller Lordship, his father name is Abdul Rahman, sorry, grandfather, and his father name is Ainuddin Sarkar, alias Ainuddin. And mother name is Lord Sharatun Nesa, alias Sabatun Nesa. He has three uncles, Kalimuddin, Najimuddin, and Kasimuddin. Those are their uncles. And married with Mujibur Rahman in 1985 of the same village. And grandmother's name is also Milad there, Kiara Khatun, the regular place 54. Only one children. Hiroshima can be seen now, Milord. Total list of 1965 is 19. Considered to be and Bhanagala both are there, Milord. Only considered to be Hiroshima can be seen. Ainuddin Sarkar, serial number Milord 64 is the name of my father. And 66 Milord, name of my mother. And Gaugura Milord issued a certificate, but that was not proof, Milord. What is on record, Milord? Annexure B, page 21. And again, we'll have Bhota list of 1970, page 23, Annexure C, name of my father and mother, there is village name of the same village, there is village Alengamari.
Which is the link document between you and your father?
That is very tough, Miller. Actually, Annexure B, page 21.
But that's not proved.
Not proof, yes.
So what else?
And on land document is there, Miller, page 31, you'll kindly see Annexure Z. You see, Ainuddin, the name of my father, other brothers is there, and my name also appeared in serial number Miller 11. In Barnacular as well as Miller in considered copy. Considered copy was given 11% Miller. And my name appeared in serial number Jahanara Dewa. Dewa means after the death of my husband, petitioner has written Miller Dewa. This 32 Miller Barnacular. And on the same land, my lord, father was paying my lord land revenue, that is page 33. And 34 my lord, vernacular. After marriage of the petitioner, my lord, the name of her name appeared with her husband, my lord. Fine.
Come to your written statement.
My lord. Minister, my lord, Annexure I, page 46.
Whether in your written statement, did you mention that your father possessed land property or you have other siblings?
I'm coming.
Have
my
you
lord.
mentioned?
I'm coming, my lord, yes.
Please show us.
I'm reading, my lord, but the second party is actually correct name is Janara Khatun. Here, my lord, I have also seen, my lord, what is written, my lord, only regarding their names they have mentioned, and they have also some landed property. There is.
Where you have mentioned in your written statement.
Yes, I have, my lord. Page 47, my lord, there are 12. That the circle officer Jala Revenue Circle issued a linkage certificate to the second.
Paragraph 47.
My lord,
Paragraph?
paragraph 12, my lord. Page 47. Linkage certificate with her father Ainuddin and husband Mujibur Rahman. Paragraph 12, yes. Husband, father Ainuddin and mother Sabatun Nisa, alias Samdeva, and her husband Mujibur Rahman.
Where is that certificate?
Certificate, my lord, from the annexers, so far annexed here, my lord, were under, I could not find, my lord. Record maybe they are recorded, my lord. Only they have annexed, my lord, here, my lordship may kindly see, my lord, page 53, what they have annexed. Exhibit A, certificate to the voter list 1965. Exhibit B, linkage certificate of Jala Revenue Office, my lord, that was exhibited. That is not with me, my lord, as a record. And on Gaubra certificate. And that Gaubra was not examined.
There is no mention about any certificate in the opinion
Certificate by?
or linkage certificate of circle officer.
No, they have mentioned here in the WS.
It's not there in the opinion. Though you have just made a cursory reference, you have not annexed that document. Not to talk about proving it in the tribunal, even before the court, there is no such document.
Yes,
Marriage probably have.
and order 63, order of the employment order, my lord.
When this was also not true. Circle officer. Relief পেয়ে যাবো, কারণ তোমার তার পুরোটা তো free হয়ে গেছে।
Certificate of revenue circle, that was annexed, and that was exhibited as an exhibit C.
That is not by revenue cycle of the site. It is, my lord, the document says that it is from the office of the circle officer, but it is signed by one Lakmandal, who was not examined, this was not examined,
It's not
his
in
name is Umar Ali Sheikh.
And Gaugura certificate also not examined.
Where is that land document? Land document?
Now that document was on the record, my lord. Record I could not.
No, in the repetition.
No, there is not annexed here. Not annexed.
Land document.
Any?
No. Land document only, my lord, one XR, my lord, that is annexed G, my lord.
Annexure?
G, page 31.
When the order of the tribunal was passed,
Order of the tribunal was passed, my lord, on 19/7, so 19 on 2017.
19,
On
2017.
17.
When did you procure this land document?
See, that document,
2020.
When did you procure this land document?
land document probably that is. Oh, yes, my lord. Page 30 on is there, there is there.
After January 2017, when you have challenged this writ petition, when you have filed this writ petition,
It is, my lord, of on 10/2020.
where is the
Has a
grounds you have
that
taken
is,
for the
that
delay?
is page 31, my lord, last below. Has a lordship got it? That I
Where is the
received.
ground for the time taken for the filing of this writ petition after more than 3 years? Almost 4 years.
For almost 4 years.
What's the ground?
Delay ground here, I have, I could not take it here.
You have not.
It is a. I'm the second advocate, so my lord,
Okay. Mr. Rasid,
my lord. No, what is
Let
the
us-
record, my lord? I am telling.
let us assume that land document. Page 32.
Yes.
Will you be able to read this?
I will try, my lord.
You can read vernacular?
I have only one copy.
You can read vernacular?
Govardhana Moujar, Telangamari, Gawar, Jawabandi, Putiliki, Pattan number,
Then come to the second remark column.
second remark.
The remark
Cheaters of-
column, second one.
Yes, my lord. Cheater, Sakro Vikar, 30/9/2020.
No, prior to that.
Then, my
তিথাৰ
lord,
চক্ৰ বিষয়াৰ 8/4/2003
2003
ইংৰাজী তাৰিখৰ হুকুম মতে
হুকুম মতে 60 নং পাট্টাৰ
উম।
301 নং আৰু 371 নং দাগৰ উত্তৰে সূত্ৰে 1 নং পাট্টাদাৰৰ স্থলত জয়নুদ্দিন
মহম্মদ জয়ৰুদ্দিন
জয়নুদ্দিন
মহম্মদ
মইনুদ্দিন
মহম্মদ রহিজুদ্দিন মোহাম্মদ
জহুরুদ্দিন
জহুরুদ্দিন
মালিকুদ্দিন রহিজুদ্দিন আইনুদ্দিন নামত
no then মোহাম্মদ মালিকুদ্দিন then মোহাম্মদ রহিজুদ্দিন পিতা
পিতা আইনুদ্দিনৰ নামত
পিতা মৃত আইনুদ্দিনৰ নামত নথি সংশোধন কৰা হল
কৰা হ'ল
8/4/2003 right
right
then next column next remark
চিটাৰ চক্ৰবিষয়াৰ 3/9/2020 ইংৰাজী তাৰিখৰ হুকুম মতে
no come to the left
লেফ্ট চিটাৰ চক্ৰবিষয়াৰ
17/6/2014
ইংৰাজী তাৰিখ হুকুম মতে এই পট্টাৰ 301 নং দাগৰ আৰু ইউনিয়নৰ অংশ সূত্ৰে পট্টাদাৰ সকলৰ লগত 1 নম্বৰ নয়নুদ্দিন, 2 নম্বৰ আলিমুদ্দিন, পিতা আইনুদ্দিন, নূৰ আইনুদ্দিনৰ নামত নামজাৰি কৰি নথি সংশোধন কৰা হ'ল। তাৰিখ হ'ল স্বাক্ষৰ 30/6/2014. It is English.
Okay, then read the last column.
বিচার চক্ৰৰেখা 30/9/2020 ইংৰাজী তাৰিখৰ হুকুম মতে অংশীদাৰ সূত্ৰ এই পট্টাদাৰৰ সকলৰ 309 নং দাগৰ অংশৰ
301
লগত
নম্বৰ দাগত
9 নম্বৰ দাগৰ অংশৰ লগত জাহানাৰা বেৱা ৰহিমা বেগম পিতা আইনুদ্দিনৰ নামত নামজাৰি কৰা হ'ল। It is ordered dated 30/9/2020. From the record, it reveals that the order was passed earlier.
উত্তৰাধিকাৰী নহয়। Now, what is the meaning of Onkidar Hutre? Onkidar means shareholder.
Shareholder.
On what basis?
It should be would have been Millard as the Uttaradik, not the
It is not there Uttaraধিকাৰী Hutre. If it is the right of inheritance, then would have been, that linkage would have been Ainuddin. Okay, to that extent you could have understood. Now, the Onkidar Hutre, the shareholder.
shareholder.
How do you explain? How would you show that that particular person was your father? Even if you assume that particular land document, which is you have obtained in 2020, which is not a part of the before the tribunal, there is nothing.
No, but here is written Millard as Pita Ainuddin.
Pita Ainuddin. That doesn't mean
Pita Ainuddin
that
means
is always can be there. Where is the Uttaraধিকাৰী?
but I am trying to say that the shareholder here Ongshidari Hutri.
What Onkidar Hutre? It is not Uttaraধিকাৰী Hutre, not by the right of inheritance.
Legally as an Ongshidar partnership or shareholder, there is not the same meaning. Meaning there is some separate. But
Anyway, this is a document of 2020. So nothing has to do. It was not before the tribunal.
it was not, yes. Admittedly, there was not. An order was passed in 2017.
In your written statement, there is no mention about your brothers, sisters.
Only
In a
Millard.
written statement, you have not mentioned that your father have any such landed property.
W.S. Millard, Annexure 1I, case 46. Only here it is that revenue officer Millard, circle officer Millard, Jala revenue issued a selling case certificate. That is the Millard. But that is probably on the record, not with me. Yeah.
Read her cross.
Millard, I was, yes. Proof was there, Millard. Yes. Case 54, Millard. Married, my lord.
Please.
The opposite party proceeding has been examined as per the provisions of the section 164 of the Evidence Act. The discovery of relevant texts as on 30/12/2016 as under. I am not about my date of birth and my age is 50 years. And I born and brought up at village Alangamari, and the names of father and the mother were late Ainuddin and late Sabaton. They were expired about 20 years, 22 years there at Alangamari. The names of the grandfather is late Abdul Rahman Haji, and the name of grandmother is Pyara Khatun, picture of Pyara Khatun. And I am not ever about as to when and where they were born and brought up. My father had no any brother, and I am also not aware about having of my elder during my lifetime.
About my elder,
Elder during my lifetime. I am not aware about the documents as being filed before this tribunal. I am also not aware about the contents of various paragraphs of my examination in chief on affidavit as being filed for and on behalf of me, of me. The name of our local Gaura is Shalom, and he has not come as witness before this tribunal today. I had applied my franchise right about 30 years back, and I am not aware about as to why my name enlisted in the voter list. I am also not aware about the facts and circumstances of the pending references against me.
then
And
In
pros, my parents were born and brought up at village Jaklivil Pathar, and my father was a landholder, and I have not exhibited the relevant documents of the landed property before this tribunal. I have not produced the issuing authority as my witness before the tribunal. It is not a fact that I am not a citizen in India. It is also not a fact that I have not produced my evidence. I reduced my forms. And BW2 also, dear Mullah, he is their brother, but he is saying that he have no any elder. But he said he is elder. Actually, what happened will in this case, one fact is kept secret. They have the stepmother. That fact will be not mentioned in WS.
where is it mentioned that your father shifted from village Dakili below Pather
No,
to
Zakili
Alangir?
Mill was the born place of his father.
Definitely,
of our
from
father.
when you have,
That is
when your
not,
father shifted from Jakilibili Pather to Alangamari.
and Alingamari, they have said that his grandfather also there, Milord, and father also was there, the Alingamari. But she is saying that Jakiliville, I have also not heard, Milord. In the record, Milord.
Come back at 2.
With the permission of your lordship, may I pray the item number 3? It may be come upon day after tomorrow, my lord, 1st March. must apply.
Okay.
Huh?
Maybe. Your lordship asked me one question regarding this statement Jackley bill. His petitioner your lordship deposed in the tribunal that her father was born at Jackley bill. In 1951, my lord, her father was there. There is one NRC copy, but which is not admissible now, but name also appeared there, my lord. That is why, my lord, she mentioned that her father was at village Jackleyville, 1951. That document, my lord, NRC copy is annexed, of course. Your lordship may kindly see page 29. Number one is the name of her father, my lord. And Ainuddin, son of Haji Abdul Rahman, is appeared in NRC 1951 in house number 92, holding number 86 of village Jackleyville, Pathan. That is he mentioned. And there is also mentioned in the Millard WS also. my lord. WS Millard that is 46, WS Millard. Paragraph 8 of Jackleyville, page 46. There the second party's father's name appeared in the NRC of 1951 in the house number so holding number so or at village Jackleyville, Pathan. Village Govardhana, PS Sorbog district, Borpeta, then Kamrup. So, origin is from Jackleyville, Pathan. Then they shifted to village that Alangamari. And the WS, of course, you have seen, it is not up to the mark. They have not clearly stated many things. DNA siblings and some other document.
Written idea.
And in page 50 of the evidence he also stated the same thing. Paragraph 6. DW1 in cross, he has still that father and mother were born at village Jackleyville, Pathan. Then they shifted to village Alangamari.
70, only 65. Common to economic. No, no, 70 is not very good. 80, 70. Maybe they, for the 10 members. 65. 70.
He did not produce 70 voters list, though it's not relevant at all. Only 65 we had produced.
70 Milot and plus 23.
Yes.
No, 70 Milot, my father's name is there.
No, no. Yeah, it was not before the tribunal.
And my mother's name is there, of village Elangamari.
94, did you? 94, nothing.
94 only father name. Yes.
No, no, they were not exhibited.
Yes. Only 3 reports are exhibited, my lord.
Which are those documents?
You will actually can see them in the written statement. Certificate को बोला 1965. Linkage certificate, Exhibit B मिला linkage certificate of Jalar Circle office. And मिला Gabura certificate. And Gabura certificate was not really examined. Gabura was not examined.
The Latmondal was also not examined.
Yes.
He was also not examined.
Only that myself and one of my brother.
How do you say that his brother? Where is his name? Where you have mentioned in your written statement? That's what we are asking you. You have
That is
produced,
also not mentioned. Fathers, only others, brothers, sisters not mentioned.
have you named them?
No, not even not Milad. Yes, you are right, Milad. Those names are not mentioned. 46. Only in WS mainly strength was given the father name is so and so and mother name is so and so. And on shifting, he was born at village Elangamari. Grandfather name is Haji Abdul Rahman. Father name is Ainuddin. That's all. But the DW2 name appeared in the Miller that land document. So, again, that was not Miller Puri. I don't know.
Beautiful. He said he- my God. The citizen. कितने का कितने का? Can you read the deposition of DW2 at page 58?
My lord. DW2 Miller, P. Mahinuddin. Yes, 61 years.
Leave those part.
Yes, but
Third
on
paragraph, opposite party.
opposite party is my sister by relation, and opposite party is Alangamari. Is of should be there. Is Alangamari. Not namely Sabaton. His mother's name Sabaton, but not mentioned. My father was a cultivator, and I am not aware about as to the measurement of the land as owned and possessed by my father at Alangamari, and opposite party lives at Alangamari with her own children, and so name of her husband was late Mujibur Rahman, and he was expired about 12-14 years back, and I am not aware about as to when she was married to Mujibur Rahman. The name of the father-in-law of opposite party is late Asiruddin. I am not aware
I think you
about.
have to read the handwritten portion. You have left out many sentences while
Yes, those are
transcribing into type copy. This is not proper.
Handwriting is also so,
No, it doesn't,
yes.
it will not allow you to permit you to write something else. Please read the handwritten portion. Opposite party is my sister, my
is
relation,
is my sister by relation,
and
and opposite party is
daughter of
daughter of
our
Second, mother.
second mother, should be, yes. Second mother,
this was
family-
not even written anywhere in your type part.
Yeah.
Second mother, namely Sebaton.
Sabaton.
My father was a cultivator.
My father was a cultivator, and I am not aware about as to the
Ah.
measurement
Hmm.
measurement
Of the land
of land
as owned
as owned and possessed
by my father
my father
at Telangamari.
at Telangamari. Actually, it should be Alingamari, not Telangamari. But anyway, Telangamari.
So he's not aware at all that his father has land. Now, not the measurement.
No, if father had land, that is no, but measurement don't know how many bigha or how many katha they have. That is not known. And opposite party lives at Alingamari with her own children, and so none of her husband and name of her husband was late Mujibur Rahman, and
He was expired about
he is expired about
14 years
12,
back.
14 years back, and I am
Not aware.
not aware as to when she was married
Married.
to Mujibur Rahman.
Hmm.
The name of her
He doesn't
father,
even know when her sister had got married.
actually, in fact, there is mentioned second mother, so there is the something is difference between them, but they reside in the same village. Village Alingamari. There are two mothers in the voter list, but there was not exhibited. The name of the father-in-law of the opposite party is late Asruddin.
Was there any chief examination of DW2?
No.
This is the seat.
Huh?
This is seat.
No, this is not chief. This is the
No, minor colleague errorship. This is the seat. Close means-
chief by way of affidavit. Is it?
Close probably there is second page, page 2, page 61. There is the cross part.
No, but did he file any affidavit by way of evidence by way of affidavit? No.
No, there is then. And even
DW2.
no, then not. No, yes, no, that is not clear. By not only he came to the court, by you have someone settlement, then his statement was recorded. And the sheep and crows is the same. In last page 61, he has mentioned, I am not aware about the neighbors of the opposite party. Only I have no one Azmot or Abzot Mistri only. Only nothing knows, or only one person knows, there is one Mistri.
Yes, Mr. Pang, anything?
And WS is not adequate at all, because in WS he has not stated when did he born, first of all. Secondly, my lord, he did not disclose about anything about his, my lord, sibling. This
Of
is,
his sibling.
yes, this is very important for the aspect. My lord, if your lordship may kindly see, the affidavit he said he is 49 years in 2020, my lord. As per the affidavit in the written of the, my lord, in the writ petition. He was 20 years in 2020. She was 20 years in 2020, my lord. So her date of, yes, 49 years, 49 years. And then her date of birth will be sometime in 1971. But she has annexed a, my lord, NRC document wherein the brother's name is shown to be appeared in 1951 at the age of 8 years, my lord. So there is the between siblings, the age difference is more than 35 years. So suddenly the, my lord, petitioner's date of birth is, will be sometime in 1971. Suddenly after 35 years, the petitioner is appearing. Petitioner is shown to be, my lord, born to that, my lord, Saraton Nessa, whom the petitioner is claiming to be murdered. That is first thing, my lord. So whether he has any siblings in between, that should have been explained in the WS. In absence of those things, my lord, apart from that, my lord, the petitioner could not, though she has submitted a voter list of 1965 of his projected parents. Thereafter, no voter list at all after 65. What happened to their parents? That has not been disclosed. Whether the parents are alive?
1997 parent is there.
Now, my lord, there is no legal documents at all to link that the petitioner to that person whose name was there in 1965. To that effect, he has brought two documents. One is from the Gambura, one is from the, my lord, the circle projected Lat Mandal, projected circle. Those are not proof. So if these two documents, which are brought as linked documents, are not proof, there is no case. Only matter then boil down to the evidence of the DW2, whom he is projecting as his brother. Now, brother has come, my lord. Brother has not brought any documents to link himself either with the petitioner or with the parents, my lord. So there is no link at all, my lord. Now, my lord, if we examine the, my lord, evidence of DW2, DW1, my lord, your lordship will find in the middle portion, my lord, may read the, my lord, page 54, the type portion of the DW2. Only 2 lines, my lord. Here, page 54, my lord.
Yes.
In the middle portion, my lord. I'm not aware about the date of birth of my age, my date of birth, and my age is 50 years and born and brought up at Alingiri village. My father name is and mother were late Ainuddin and Sabaton. They were expired 20 years back, Alingiri. The name of grandfather is so-and-so, name of grandmother is so-and-so. I'm not aware about as to when they were born and brought up. Now, my lord, this part. My father had no any brother. This is clear statement, positive statement from the petitioner. But in writ petition, your lordship may kindly see. Para 3, my lord. Writ petition at para 3. He has said the petitioner has 3 parental uncles. Para 3, my lord, writ petition at page 4, my lord. The petitioner has 3 parental uncles, namely late Kalimuddin, late Kazimuddin, and late Kasimuddin. But in evidence, my lord, she has clearly said, my father had no any brother.
In the DW2 has it.
DW1, my lord. So petitioner proceeding herself.
Page
54.
4 or page 54 is the
Yes.
54 is the DW2, I think.
No, DW1, my lord.
Oh, it's DW1.
Proceeding herself.
Okay.
And I am also not aware about having of my elder during his lifetime. So, in fact, My lord, then those person whose name is, though the 70 voter list was not exhibited, NRC was exhibited. NRC is, though, even though it is not admissible, my lord. In NRC, there are not names of brothers and sisters. Elder brother's name is there. That means, my lord, if your lordship may kindly see the NRC, 1951. NRC page 29, my lord. She has said she has no elders, my lord. But from page 29, my lord, the original is page 30. Even though this is not admissible for the purpose of evidence, but from here it shows, my lord, one Ainuddin is there, who is son of Abdul Rahim, one Kadbanu Bibi, wife of Ainuddin is there, one Sabetan Nisa, wife of Ainuddin. Now, my lord, Hartan Nisa is daughter of Ainuddin. Naim Ali is son of Ainuddin. Joinuddin, son of Ainuddin. All these were there. They were, my lord, 11 years, 8 years, and 3 years in 1951. But this petitioner, who was born in only 1971, my lord, said, my lord, he has no elders, my lord. I am also not aware about having of my elders during his life.
He has stated, I am not aware.
Yes, of having my elder. My lord, it is the proceeding who should know everything, my lord. It is her personal knowledge. If he doesn't know, she doesn't know, my lord, that she has any elder brother or sisters. So how can she bring this DW2 as a evidence, as a witness?
Where
prove
she
her
has
case?
said that she does not have any elder?
My lord, same line in the page 54, my lord. My father had no any brothers, and I am also not aware about having of my elder during his lifetime. Now, second part is, my lord, she has filed up, my lord, evidence. Now she has,
Of any of my elder.
yes, my lord.
No, what is the, I think the transcription is wrong.
Transcription is
Just
Madam,
from page 56, you read, Mr.
page
Pai.
56 also, my lord, it is like
I
that
am
only.
not aware about
I am not aware about
Date of birth
I am also, my lord,
or age.
I am
Or
also
my-
not aware about
My date of birth or my age. Or my age is about
Not by
50 years.
To whom and where?
my elders. It's like that only, my lord. I
I
am
am not aware
I
about
am not
not
aware.
aware
about-
about having of
to whom something.
No. About the
Having-
documents. The documents.
the documents. It is different prior to that, my lord. Documents, I am coming to that.
The handwriting is very.
My lord,
56.
your lordship, my page 56, my lord, middle portion. My father had no any brothers. And I am
I am not aware.
Aware-
About having,
having, yes, my lord,
having.
having of my, this
Having-
part is, my lord, probably. This part is,
Having,
I am also not aware about
having of,
my elder.
this is my elders problem.
No, this is not elder. Having of. Any illness during his lifetime? No. Having of any.
Even though this part is ignored, my
my
lord.
father had no only brothers.
And
No any
and-
brothers.
I have not any brothers,
Yes.
any brothers.
No any
And
brothers.
I am also
of any
not aware-
sister. Any sister.
I am also not aware
Of
about
having any
having
sister.
Any sister problem. Yes.
During his
Every
lifetime.
sister.
That means his
Yes.
paternal,
Paternal.
her paternal,
Hmm.
uncle or aunt.
So he is
Yes, ma'am.
alone.
Probably that is not elders. Now, my lord, next part, your lordship may kindly see. She has filed, my lord, written evidence Now she has demolished her written statement herself. Then she started saying, madam, I am also not aware about the, I am not aware about the contents
Of the various paragraphs.
of various paragraphs.
Of my
No,
examination in chief.
aware about the documents, my lord, as being filed before this tribunal. Next to that, the sisters, my lord, I am not
Yes.
aware about the documents as being filed before the
So
tribunal.
just pause for a moment. The first point which we are trying to urge of there being 4 children in 1951, she's saying no, all that, but perhaps that would not.
Yes, that is that problem. But she has said, my lord, she has probably directly here said the father had no brother at all, no any brother.
Okay.
But in my lord, para 3 of the my lord writ petition, she has clearly said she had 3 brothers. Father had 3 brothers.
Okay. That is okay. But children, I think there's.
Children probably, my lord, that is not. But children, my lord, what my thing is that, my lord, from the NRC 1951, we can see there were 3 children.
But she has not stated anything in the.
WS. Nothing has been stated in the WS.
In WS also in evidence.
Evidence also. In fact, she has said, my lord, what she has stated, the documents, what she has submitted, they don't know in her evidence. And she also stated, my lord, what is there in paragraph in the evidence, I don't know anything, what is there in the evidence. So what remains, my lord? And in cross, so she herself demolished the, my lord, entire facts and the things, whatever she has submitted in her evidence. Now,
So. Any decisions you'd like to cite?
yes, my lord, only your lordship may kindly see, to that effect, I would like to, with regard to the brothers' evidence, your lordship, I have already pressed 2-3 judgments that Bijoy Das was there. With oral evidence. Then your lordship may
No,
kindly
citation.
Bijoy Das, my lord, 2000. WPC 562 of 2016.
Date of disposal.
5/6/2016.
6-2.
5/6/2 of 2016. Date of disposal, my lord, is this is reported, my lord, 2018 3 GLT 118. 2018 3 GLT 118. There para 17, my lord. Rely. This is on oral evidence.
Oral evidence without being corroboration, without there being corroboration of. by
Yes, documentary.
contemporaneous document.
Yes. On the same line, my lord, another 2 judgments I refer to. This is, my lord, 2000. 1900 2019, my lord.
1900.
Yes, ma'am.
2019.
Yes, ma'am.
This is also oral evidence.
Oral evidence, Noor Begum.
Noor Begum.
Yes. They are in para 6.
Date of disposal.
Date of disposal, my lord, is 18/02/2020. And another one is on oral evidence, my lord, 40/20/2017. Asia Khatun, my lord. Disposed of on, my lord, 21/11/2019. inadequacy on my lord, filing WS, inadequate WS, my lord, your lordship may kindly refer, this is 2017 3GLJ 490.
Which one?
My lord, this is on inability, my lord, inadequate WS, my lord. Where the brothers and sisters' names are not mentioned. My lord, properly. Siblings' name,
2017?
3GLJ 490, my lord. Aisa Khatun.
I said already 402017. It's a different one.
Different.
This is a different one.
Huh? I think same.
No, no, no. That is different. That is Asia, my lord.
Yeah, this is.
That is Asia. This is Ayesa. AYESA. Aisa Khatun. Para 12, 13, and 14 will be reliable. Then with regard to the other documents which were submitted but not proved, mere exhibition of documents will not do. That has to be proved, my lord. For that, my lord, your lordship may kindly refer. This is 2010 4SCC, my lord.
2010 for SCC.
Yes. 2010 4SCC 491. Life Insurance Corporation of India and others versus
Oh, that's
Rampal.
old case, yes.
2010.
Yes, ma'am. 2010 4SCC 491, my lord. My lord. My lord may refer para 26, 27, and 31, my lord.
26, 27,
Yes, ma'am.
31.
31. This position has been affirmed by this honorable court, my lord.
Yes.
The same position has been affirmed by this honorable court in my lord foreigner's case. This is in 2017 4 GLT 346.
2017.
4 GLT 346. Rosmi Nara Begum.
What is the proposition?
Proposition, my lord, the
Follow code.
documents,
Same
evidence
same
does not.
proposition.
Yes, same.
Marking of the documents
Yes.
as exhibits will not
Not
dispense
true, my
out
lord.
with
It has to be proved. my
proof
lord.
of requirement of proof of.
Contents of the. No, that is in a different case by the Supreme Court, but in
Doesn't
foreigners
matter,
case,
No,
yes,
there is two words. One is contents of the document,
is a
one
different.
part, and the document itself to be produced.
Yes, my lord. And my lord, the truthfulness of the contents of the document, that has to be proved. Truthfulness of the contents of the document, because the documents, by proving that document is okay, my lord. The contents of the documents is okay, but how far it is proved, true or not? How far it is, that has to be proved by my lord.
Concerned person who
Concerned
have issued that particular
Yes, my.
certificate or document, whatever.
Here, para 31 and 33, 32, my lord. And to claim, my lord, claiming of, I like to refer this, my lord, because I always used to refer this point with regard to the matter claiming of the person whose name is there in sometime in voter list. That will not do. That has to be proved by bringing some other evidence, my lord. That is in WPC 2370/2023, Aziz Mia, my lord.
What is the proposition?
Proposition, my lord, that
2370 of
2370/2023, my lord. Aziz Mia decided on 9/6/2023, my lord.
Dada Bujarbur was of judgment.
Yes, my lord. Para 14. my lord, the proposition is that, my lord, once a person claim that he is my father or mother, that will not do. That has to be proved by bringing materials evidence to the defect matter. Para 14 clearly says, we constrain to observe that mere claim by a suspected person by referring to a voter list claiming a person therein to be his father is not a conclusive proof, and that by doing so, the person has discharged the burden that he is not a foreigner. This is because there is also further requirement to prove that the person who is reflected in the voter list relied upon is actually the father of the person who makes the claim. The claim will have to be substantiated with further materials or materials acceptable to the law. So, in respect of this, my lord, as both the documents were not proved, only the
Link documents are not.
proved, only
The voter
evidence
list, only the name of the father is there,
father is there,
projected father.
projected father. And my lord, the brother has, though projected brother has come, his name was not there in the WS, nor in the evidence. He has suddenly appeared and given an evidence, bringing no materials with connecting the my lord father either to the parents or to the petition. So the tribunal has committed no error, my lord. That's my humble submission.
Want to reply?
Probably I think is left, but my learned friend said that BW2, he brought me two exhibits, my lord, for her evidence, my lord, for his evidence. There is, my lord, exhibit B and exhibit E. There is, my lord, page 58, lecture K. Last line, my lord. I have exhibited the certified copies of the two voter lists, that is, my lord, exhibit B and exhibit E. But again, he has said, I am not aware contents at all. So, my lord, again, it is against me.
By himself, what he has said also demolished.
What I am saying, my lord, that is against me. I am denying myself, my lord, my case. But one thing, my lord, he said, he is a citizen of India. The 59, it is not a fact that the opposite party is not a citizen of India. That means he is a citizen of India. And everything has happened, my
Opposite party
lord,
is
not a citizen, and that in handwriting copy is there, my lord, that is last page, then all give me page 61. From below, my lord, second
by
page.
saying that same thing will do.
No, he is admitting, my lord, there is space. And everything has happened, my lord, as because there are two mothers. Sister mother is there. Probably this person from the first mother, and the proceeding your lordship, he is from the my lord, second mother. And there may be some dispute, etc., anything. And so distance is here. Anyway, my lord, your lordship may consider. Now I have reported, my lord, day before yesterday, that the person, my lord, is suffering from serious illness in hospital and jail, my lord. He is in custody, my lord. So
Take care of that.
that person, my
right?
lord. And I filed actually for bail, my lord, but your lordship has taken that main case, so it will be clear, my lord. Earlier he was granted bail, my lord, but could not execute the same. So my lord, police arrested her, my lord, and now he is in jail for about last 4 months. 30th October, she is in jail.
My lord, one submission, my
And
lord,
age is about, my lord, her, as from calculating anything, my lord, age of 50 years.
Annexure G, my
See,
lord.
the court passed an order granting her
Bail.
bail, right?
My lord.
She did not comply. She did not appear before
It
the,
is actually it is a fault of the petitioner.
that's the
Admitted.
order was of 22-1.
21.
She did not appear. And that fixed.
At any rate, she could not
And
exert or
then
she
ultimately the court itself recalled that order. Right?
definitely my lord, will be. Order was passed on 15/3/21. And when the honorable court passed order, my lord, it should be honored.
And she was, when she was taken into custody,
30th October, my lord.
when, which year?
23, my lord.
So from 21 to 23, the proceeding did not appear before the concerned Superintendent of Police Board.
Actually, she tried to appear through her advocate, my lord, but there was some gap between them, my lord, so it was not. And ultimately, false, my lord, allegation will come on me. I'm the proceeding, I'm the petitioner. I have mentioned in my I, my lord, so on that point also. How it was not able to exhibit. Now she is in a temporary jail, Golpara, my lord.
The present challenge is with regard to an opinion that is also the hearing is concluded. There are present the result. Any matters which are thought for this bench will have to rise early. Short and urgent. Mr. Islam.
Item number 1.
You want to withdraw?
No. But what is the case is that ex parte opinion has been passed. And after verifying the credential of the petitioner, the inquiry officer had observed that the petitioner is an Indian citizen by birth. And that observation has already been accepted by the supervising authority also. Thereafter, referred the matter to the tribunal. And tribunal taken up and issued notice, and subsequently ex parte order has been passed.
Why ex parte?
Well, ex parte means
You did not, after receiving our notice. you did not
notice has been received. I have already stated in my petition. What had happened, after receiving the notice, the petitioner came and contacted with a lawyer. Then the lawyer, after verifying the record, when he has seen that the inquiry officer has given an observation that the proceeding may be dropped, he suggested the petitioner that need not to appear. Then he returned back. Then on the next day, the opinion has been passed. But here in this case, my lord, the tribunal ought not have been registered the case as FT case, my lord, since the reference is very clear. No doubt about his citizenship has been.
What you can say. এইবিলাক আমাৰ অৰিজিনেল পুলিচ ৰিপোৰ্ট আৰু
The initial report were under which earlier act, IMDT act.
No, my lord. This act, my lord, the reference is at page 39.
police.
Reference is just page 30. This is in 2018, madam. The reference case number 72/2018. Not for in the earlier act. And in this respect, my lord, one judgment of these honorable court is very clear. And the 2072 GLT, the Santosh Das versus Union of India.
What has been said?
My lord, the proposition the tribunal gets its jurisdiction to render its opinion only when a reference is made to it. Without a reference being made, the tribunal cannot exercise its jurisdiction to opine that a person is or is not a foreigner. It is only when the reference is made as above that the tribunal assumes jurisdiction to render its opinion. Therefore, the tribunal would have to confine to terms of the reference made by the referral authority.
Here is a case where reference has been made.
But with an observation that the proceeding may be dropped.
No, we are on a finer point. See, not making a reference, the tribunal definitely won't be vested with the jurisdiction. Jurisdiction comes only when a reference is there. Now, the initial inquiry may end up in two results.
Yes,
One is doubting your citizenship, so therefore give him a chance
yes,
in the adjudication process.
yes, madam.
One is not doubting your citizenship.
Yes,
Then the report is given, no, we have inquired.
Yes.
Under the second circumstances, what would be the role or the next step by the tribunal?
but in that case, my lord, in the another judgment.
Because the judgment which you are saying that there has to be a reference.
Yes,
Here, the reference is there. The outcome of the reference is different.
but
We are
in,
not on that.
in that case, Manas, I like to point out one judgment of Poranuddin, wherein it has clearly said if the tribunal think that the reference is faulty, then his best course of action to remand back the matter to the referral authority
That
for
will not
fresh
help, that
reference.
will not help you.
Order 3,
The
72 rules.
tribunal has not,
64 rules.
has not said the reference is faulty. But will the tribunal still would have the scope to have an adjudication process? Mr. Pai,
Yes.
In that judgment, my lord,
what is the next judgment?
my lord, the first one is Santosh
No,
Das.
second one, Poran.
Second one is Poranuddin, alias Poran Ali, 2017 5 GLT ballots.
First one is
First one is ballot 2017 2 GLT 106 by Santosh Das.
2 GLT.
2 GLT 1065 ballot.
The second one,
Second one is ballot 2017 5 GLT 831 ballot. Paragraph in first one 14, 15 and 16 ballot. Section para 14 ballot, section 3 of the Foreigners Act 1946 for the central government to
That
make.
first one may not be too much of a relevance because there it says until there is a reference,
Yes,
tribunal will not get the jurisdiction.
Yes.
Here there is a reference. But reference says that he is not a foreigner.
yes,
no,
That
the reference not a foreigner.
yes. He is an Indian.
That's what difficulty is. The record clearly reveals.
Malad,
Initially, they were found to be a foreigner and their fingerprints and photographs were taken. Then they left that place.
yes,
They become untraceable. Then what happened? The police wrote to the concerned police station where their permanent addresses was given. The report came saying that the proceedings are
Is an
Indian
is an
citizen
Indian citizen.
by birth,
By
nothing else.
Yes.
Only that report,
yes.
there is no document, nothing, only by birth. The ultimately, when it was finally inquired, they said that untraced but Indian as per NV report received from Insars Koyakusi.
Hmm.
Right?
Yes. Sir.
Then after inquiry, the report goes like this.
The
The concerned
suspect is an
inquiry
Indian.
officer. During the course of inquiry in a prima facie manner, it reaches
Me
that
that.
the suspect of the case, such and such and such and such, left
Add-on
his
is- Yes.
present address at Guwahati
Hmm.
permanently for his native village,
Hmm.
Sokirbija, district Borpeta, Koyakusi. And we reply received from Insars Koyakusi by such and such that the suspect is an Indian by birth.
Yes.
Then the case may be dropped,
Yes. Sir.
but hence the risk can be dropped, forwarded to the Honorable Forest Tribunal Court, Kamrup, Guwahati, for kind opinion judgment. That is his recommendation. So it
Yes.
is only the tribunal to decide,
Yes.
not by, because whether a person is a foreigner or not, it has to be decided not by the concerned inquiry officer. It has to be decided by the tribunal. That
Malat-
is why for that purpose, whether the proceeding is a foreigner or not, it has been matter referred to the tribunal to decide.
But in that case, Malat, in the Poranuddin, where the reference was made that the proceeding entered into the territory within a period of 1966 to 1971, the Planet Furnace Tribunal declared him as foreigner after 1971.
Possible.
In that
because
case, Malad,
if
this
somebody-
judgment said that the tribunal should confine with the terms of the reference,
Once.
not beyond that.
No, that is what we found. If you say now, after the judgment of the apex court in the Sarvannational 1,
Yes.
it is very specific that all such proceeding has to be considered under the Foreigners Act.
Yes.
Under the Foreigners Act, it is only the tribunal to decide whether the proceeding is a foreigner as per the section 6 within the group of first group 66 to 71, or it is after 70. That the inquiry officer cannot fix the period. Because it is what in another judgment, probably Justice Manojit Bhuya had discussed a little about that. But thing is this, in that particular thing, it is you have to follow the Foreigners Act. And the tribunal, it is only to decide of if a person is a proceeding is a foreigner, then of which era, 66 to 71 or after 70. But reference has to be made by the police to the tribunal.
But in some cases, Malad, I have found that the tribunal should confine with the reference made by the referral authority. And if the tribunal thinks that the reference is faulty or somehow some problems is there, then ought to have been referred back, returned back to the referral authority for fresh reference. And if the reference for the period of 66 to 1971, then tribunal should have confined with the reference. Tribunal cannot declare the petitioner foreigner after 1971.
That point has been distinguished, madam, now. In your lordship may kindly refer this.
But in Poranuddin is the same ratio.
Therefore, madam, your lordship may kindly prefer this WPC 2279 of 2021. Rukia Begum Borhuya. 2279 of 2021, madam. Rukia Begum Borhuya. Decided on 12/06/2023.
I mean,
Two two seven nine now, which year?
2021, madam. Here, one parameter I would like to refer your lordship may kindly hear. Take note, my lord, para 21 here it is said. We further added, owing by statutory provision of clause 2(1) of the Foreigners Tribunal Order 1964, any reference would have to be understood to be reference to the tribunal on the question whether the person so referred is foreigner or not, within the meaning of Foreigners Act 1946. So here is the references, here the reference is whether he is a foreigner or not.
In
My
this particular judgment, Justice Bujarbura have discussed to certain extent.
Yes,
Prior to
discuss
this,
everything.
Another judgment of Justice Bhia, it is there.
Yes, ma'am. And
Term
where
cannot be fixed.
term cannot be fixed, ma'am. Where again foreigner is given the meaning of the person who is not a citizen, again where the citizen is defined under Citizenship Act 19. The tribunal, upon doing the needful and after examining the evidence in material shall pass reason order.
That's what it is.
So whether the reference can be, my lord, whether he's a foreigner or not. Two reference. So same is the fact here. They doubted, my lord, initially doubted that he's a foreigner. Then later on, there is a report submitted that no, he's not a foreigner. Now it is to be decided by the tribunal whether he's a foreigner or not. That is the reference, man.
But the reference is very clear that the proceeding may be dropped.
No. That is
Yes.
that is
Reference is clear
I understood.
on that issue.
The last
The
part,
proceeding may be dropped. So in that case, if the tribunal found that
proceeding may be
the
dropped.
reference is faulty,
No, that is
then
not faulty.
that ought to have been remanded.
The sentence is, hence the case may be dropped. It is
Yes.
not case may be dropped. Forwarded to the
Simply
forwarded the
forwarded.
honorable FT Court Kamrup Guwahati,
Yes,
kind opinion and judgment.
yes.
But if there are prima facie no materials to come to the initial conclusion that a particular person is a foreigner, is there a scope of a further adjudication process?
My lord, by the police.
No, by the
By the
tribunal.
Tribunal. There is
The
no
adjudication process is only to facilitate a
facilitate
person
in
to
the,
defend himself by giving cogent, reliable, and acceptable evidence.
yes, my lord,
Now,
that
if the
must-
initial report says that he is not a foreigner.
Yes.
Is there any requirement or any scope or opportunity for the tribunal?
my lord, the problem here is, my lord,
There must have been many cases of this nature where there has been report which may be called in favor of the proceeding.
proceeding.
And thereafter, what to do? What is the procedure
Yes, my
later
lord.
on?
Once it is dropped, suppose, my lord, he has brought enough evidence before the police court.
Yes, exactly.
If everything is submitted, if that is accepted, that can be accepted, police can drop it there itself. It may not be sent to the foreigners tribunal. Then it is not necessary to send to the foreigners tribunal. If it is a clear case of,
This involves a very thin line of difference.
yes, my lord,
Police concludes on their own,
yes,
and in another case, police thinks that I'll since tell it to the tribunal. We
Yes.
can note that we have not found any
yes,
material.
Yes.
Under those circumstances, what will be the process? What will be the next course of action? Substantially, there is no difference between the
No.
first and second. There are no materials there, no materials here. Police exercise discretion, drop it there, and in another case, send it to the tribunal.
yes. So that point, my lord, that is why, my lord.
There may be something,
Yes,
some
In fact-
procedure later.
my lord, this, in this judgment, it is discussed. Clearly, my lord, it has been
Because what
discussed.
Mr.
elaborately.
Islam was saying, referring to Puranuddin, that even takes care of a situation of a faulty reference.
Yes, faulty
That
reference.
means the tribunal might think that there are materials, but still you have come to a conclusion that he
Yes.
is not a foreigner. So no, I refer you back.
Yes,
You make a further inquiry and come back.
Fresh reference.
yes. My lord, what happens in sometimes what police do, my lord, even though there is not a single documents of 1966 to 71 in between period, they send a reference that the proceeding is suspected to be foreigner within the period of 66 to 71.
Okay, and that will be a faulty reference.
Faulty reference. In fact, the proceeding has not submitted any documents of 66 to 71.
So
that
you
is a
make a
faulty-
re-inquiry
Yes,
and come back.
come back.
Okay.
Sometime again, my lord, the
tribunal, no, here records are very specific. After you receive the notice, you did not appear.
Yes, my lord, that has I've already pleaded.
Go to the record. Your time is running out. Go to the record. A, B, C, D, E, F, G. The report came from the in charge of that Koyakuchi police station. See what is there. Whether on that basis, what kind of inquiry do you think any such procedure? You are serving at, you are working at Guwahati as a vendor, vegetable vendor.
Yes,
After police took his fingerprint, he left, vanished from his place, his Guwahati. From the initial page, you just see. Then there is an annexure G, the report of the in charge of Koyakuchi police station. See. Hereafter in 2018, you will see the first data report, why it was forwarded to the tribunal.
Okay.
Mr. Chaudhary and FP bench.
Father, I am waiting for a matter in the next minute.
Thank God.
fix it.
Tomorrow,
Well, tomorrow I have some personal difficulties, my lord. Any other day, my lord. Next week.
tomorrow you have difficulty.
Yes, my lord. Any other day, my lord. When, my lord?
Twelfth,
Obliged.
Nine circumstances, this review petition had to be filed. My lord, going by the office note, there is a delay also, my lord. So we have filed an application seeking condonation of delay. But only thing is, my lord, in terms of the order, the date is, my lord, today. The consideration by the state is not complete as yet. So if we read, my lord, para 9 and 12 together, the later days, a period of 60 days stipulated in para 12 of your lordship's order, presupposes that it will be either rejected or allowed, something whatever it is. So same having not done, my lord, can I pray, my lord, till your lordships takes a call on the, my lord, some, my lord?
No, that was, my lord, to be done by the revenue authorities. Now, if the revenue authorities has not complied with your lordship's order, it's a case of contempt. It's not a case of review, my lord.
No,
There cannot be any re-hearing on merit, my lord. Revenue authorities, assuming, my lord, they were directed by.
Why they are sitting over the matter?
That I will take instruction, but that cannot be a ground for review, my lord. That is a ground for contempt.
No,
And there was no outer time limit for the revenue authorities to decide. The outer time limit was for the petitioners to leave the place, madam.
If your lordship would kindly come to page 40, my lord. Para 9, in the event of their filing such application within 28/12/23, which we filed on 27, concerned authorities in the state respondent shall dispose of such application of the appellant for allotment settlement of government land in the Guwahati city within a period of 60 days, that is 28/2/24. Now please come to para 12, my lord. For those appellants who submit their application seeking allotment settlement of the government in Guwahati city on or before 28/12/23, respondent authorities shall not take any coercive action against them for their eviction from the said reserve forest until the next 60 days, that is up to 28/2/24. So naturally, my lord, the lordship's observation in para 12 presupposes that in terms of 9, they will complete the exercise. This is one, my lord. Now, why I have filed the review is on a different ground, my lord.
And my lord, this was a consent order, my lord.
No, that
Agreed upon by the
that
party.
is the precise ground of review, my lord.
That cannot be, my lord. A senior counsel made a concession, my lord. They agreed with the order. Now they have replaced the lawyer and they have come and that was not an agreed order. My lord, may produce the video recording, my lord. Out of own volition, he made admission, my lord. Paragraph 7, my lord, may kindly produce. Because I can recollect, my lord, my lord was supposed to dismiss the petition, my lord, because they agreed to this proposal of mine, my lord, so it was not dismissed. Paragraph 6, my lord, I have given this proposal. Further time to. One very relevant aspect, my lord. Even assuming, my lord, the district revenue authorities, not assuming, my lord, if the revenue authorities come up with an answer that is negative to their prayer, my lord, they don't agree for grant of land, my lord. Then also they will try to continue residing inside the reserve forest, my lord, because my lord has not said it is to be allotted, my lord. Their applications will be considered. Consideration may be either way. Then also, my lord, they will be saying that basically by this review petition, my lord, the petitioner wants to ascertain that their lands are allotted, and till the lands are not allotted, they will remain there, my lord. Though there is no positive mandamus to that effect, my lord, to grant land, my lord. Consideration was the order, my lord. Article 215
226 on review.
226 of review করলে কিটা না হবে?
No, my lord, whether there is an application of Limitation Act where proceedings under 226 before the learned single judge or it appeal. My lord, there are, I think, my lord, in one judgment, Honorable Justice James Sharma said it is not required. I think subsequently a division bench headed by Honorable Justice Ansari has taken a slightly contrary view. Therefore, my lord, to avoid that controversy, we have filed this application. It is a fact, my lord. In a proceedings under 226, Limitation Act has no application. Because review is under 226 itself. Going by that 63 Supreme Court. That's that besides the point. My lord, the predicament of these petitioners are, when we go to dispute, my lord, impression is given that Guwahati High Court wants that it should be done. Now, Guwahati High Court, because why they refer to Guwahati High Court, my lord? There is in fact order in a PIL. Now, against that order, there was a Supreme Court appeal. That order I would like to place. The reason why we have filed the review. No, naturally no. Well, as far as this proceeding is concerned, if your lordship would kindly have a look at first single judge's order at page 40. Para 9, I have already placed. No, sorry. That is your lordship's order, and single judge's order is at 75. Roman 3. It is clarified that all the petitioners, including those petitioners who are in possession of reserved forest land, would be at liberty to file applications seeking allotment settlement of the government land in Guwahati city, provided they meet the eligibility criteria as stipulated in clause 14 of the land policy.
Mr. Chaudhary,
My lord. My lord,
there are two groups of people here.
yes, those who are staying in government land, others in forest land.
Now, these are the petitioners who are in
The forest land.
kindly come to para 4 of that decision, our decision. Para 4.
Of your lots, division bench. No. Yes.
Kindly read.
Sri so-and-so appearing on the appellants made a submission. Though certain prayers are made by the appellant in this appeal, they are not pressing those, but made a limited prayer that they should be allowed further 90 days time after expiry of the time period as specified in para 43(1) to remain over the land in possession involved in this case so that they can approach the civil court for their relief.
We consider that aspect.
Well,
and
question
granted
of
60 days
question of going to civil court does not even arise.
See, we are not, we have basically the order of the learned single judge.
Yes.
In that case, you can also. see
No, my lord, we have got, that's why we are in review, my lord.
Para 14.
No, I do admit, my lord, there was a concession given by the learned council. We are not disputing that, my lord. But question is, my lord, why we file the writ appeal if we have to give the concession? Our case is, my lord, we never gave any such instruction. It is not that, my lord, the proceeding was adjourned for a day or two, and thereafter, my lord, instruction was sought, then it was placed before the honorable court. So, my lord, our case is, this instruction was never sought. Maybe in our interest, this concession was made, my lord, that we are not disputing. But then, my lord, this concession was not given. We are on oath. That is the statement we have made. Now, I am on a slightly different plank, my lord. Number one, there was no concession. And number two, please have a look at the Supreme Court order, my lord, because it has got an important bearing in this case, which could not be brought to your lordship's notice in spite of exercise of due diligence. Please have a look. It's a one-page order, my lord. Lordship would recollect that there is a PIL which was so moto registered by this honorable court, 78 of 2012. And in that, my lord, an order was passed on 9/12/19, whereby, my lord, the authorities were directed to, clear all these garment and forest lands. It was in that context this appeal was filed, my lord. If your lordship would kindly come to this order. Can I read that order, my lord? Yes. The principal grievance of the petitioners before this court is that peremptory directions have been issued by the High Court, which are likely to be construed as having been issued after recording finding of fact that petitioners and similarly placed occupants in the concerned area are unauthorized occupants. This apprehension, in your opinion, is misplaced, for the tenor of the order, which is impugned in this special leave petition, is merely to direct the Deputy Commissioner to proceed against the unauthorized occupant in accordance with law, which presupposes that Deputy Commissioner must examine the claim of each occupant on case-to-case basis, and after recording satisfaction in the light of evidence produced before him, proceed to pass appropriate order as per law. We may add that if the order is adverse to the occupant, the Deputy Commissioner must give reasonable time to the occupant to take recourse to appropriate remedy as may be permissible in law. In other words, Deputy Commissioner shall decide the proceeding uninfluenced by any of the observations made by the High Court in the imputed judgment. It will be open to the Deputy Commissioner request High Court to extend the timeline specified in terms of the imputed judgment order, which request we are certain would be considered appropriately by the High Court. So, my lord, what follows from the judgment in my humble submission is whether we are unauthorized occupant, it cannot be decided en masse, my lord. It has to be decided on case-to-case basis. And if the, my lord, that proceeding goes against the, my lord, the occupants, then the occupants must be given time to pursue their remedy. So that procedural safeguard, my lord, we could not avail. That is why we are on review, my lord.
Just take this, we'll come back to you.
Yes, fine. Permission they can.
Regulated.
Not today. Not today. Sir, can I make one submission, my lord?
Yes.
My lord, Lordship may like to issue notice on the review, my lord. Let my learned friend also obtain instruction, my lord.
We'll dispose it of.
Then, my lord, our submissions are twofold, my lord. Lordship may kindly take note of our submissions.
Mr. Goswami. Whether the petitioner number 1 filing a reply
Yes, yes. We have annexed that.
to the affidavit filed by respondent number 7 in WPC number 1767/2012.
Mane affidavit in reply to the affidavit in opposition, respondent number 7 is written affidavit filed position. Against the reply filed position. Petition number 1.
There are 2 affidavits of the divisional forest officer. Respondent number 7 in 1767. Now against which the appellant number 1 filed their affidavit. Do you have the entire records of WPC 1767?
I have the records of BJP, in all the records of WPC, not there.
No, one,
No, single না reply.
let us.
Oh, reply to কোথা আছে?
No, they have not filed.
Not filed.
They have filed against one and two,
One and two.
not against the respondent number seven.
Is
Yeah.
293.
293. Ratneshwar Kolita, it is there, my lord.
That's one and two.
Huh?
Against one and two.
One and two.
Oh, against one and.
There is no other reply.
I think,
বহুত পিছত দিছে না 23,670
আমার বস্তুটো পেজ 82 চলে যাবে।
হ্যাঁ
82 মানে ঠিক আছে।
Kali log into record for WPC 17. That will take up tomorrow. Tomorrow. To have the record. We are not passing any, you are taking up tomorrow.
my lord, tomorrow second half I will not be there, my.
First half, 10:30, 10:15. Record for 1767. 2012. Which is under the review to earlier 2001, 7, 6, 7, 2012. Readable is here. Huh? 10:15. তাহলে we are
Maybe I will give it
Mr. Chaudhary, take up at 10:15.
Well,